Dear students, until now we were only dealing with the offences committed by a single individual, right? Here, in this 7th video, I am dealing with the concept of group crimes and group liability. You will thus get to know how IPC is dealing with such group offences and how each one's culpability is determined. So primarily, you need to understand that in criminal law, there is distinction between culpable party and innocent party. Of this, culpable parties are basically of 4 different types. They are perpetrators, abettors, inciters and helpers of culprits post the commission. To understand it properly, first you need to know the meaning of principle of complicity and concept of constructive liability. Complicity is an act of helping or encouraging another individual to commit a crime. It is also commonly referred to as aiding or abetting. Even though in the eyes of law these individuals do not actually commit the crime, it is still considered as culpable for his or her actions that helped someone in the commission of the crime. The doctrine serves to punish individuals who have played a distinct role in the commission of an offence without regard to whether they were or not present at the time the crimes were committed. The very next concept, constructive liability, also known as the rule of joint liability, the essence of which is in the existence of common intention or common object which actuate the offender to commit an offence. Maybe these concepts need further explanations. So let us understand how the common law divides guilty parties into principal in the first degree and principals in the second degree or accessories. Principals in the first degree are the persons who perpetrate a crime directly. In other words, those who actually commit the crime or offence with their own hands. For example, Mr. A committed theft by stealing the wallet of Mr. B. Here, Mr. A is the final perpetrator who performed and hence he is principal in the first degree. Now let's understand who are principals in the second degree or accessories. It means those persons who did not perform the offence but who assisted or aided them. The reason why different degrees of principals were classified under the common law is basically to reduce penalization for persons not really or right away involved in the crime itself. So within the principals in the second degree, there are sub-classified as 1. Accessories before the fact, accessories at the fact, accessories after the fact. So let us understand its meaning one by one. An accessory before the fact is someone who assists, aids, incites, abets or encourages another person in the commission of a crime. An example of being an accessory before the fact is a person who provides the tools necessary to rob another person's home or business. Or the other example would be giving someone the keys of a car so as to assist him in using for the purpose of kidnapping. So all the facilitators who enable principal offenders in performance of a crime would be accessories before the fact. So what do accessories at the fact mean? It indicates accomplices who are at the crime who facilitated at the time when crime happened. Suppose, for example, Mr. A is planning to break into a warehouse and steal property belonging to the warehouse owner. Mr. H accompanies Mr. A and stands at the warehouse and distracts the warehouse night watchman while Mr. A breaks in. Here, both Mr. A and Mr. H equally contributed to the finality of the crime since both were present and aided to make the crime happen equally. So, unlike accessory before fact, accessory at the fact or accomplice carry more culpability. Let me make it easy for you by dealing with this famous case of Emperor versus Barendra Kumar Ghosh cited as 1925-27 Bombay Law Report 148. In this case, there was this postmaster, the victim, who was counting the money on the table. The accused people as a group came there with arms and demanded the money. When the arguments were happening, one among them pulled the pistol and killed the postmaster. Just after that, all in fright had run away without taking any money. Of this group, one Mr. Barendra Kumar was, however, caught with a pistol in his hand. So he was tried for murder along with common intention, which is covered under section 34 of IPC. Understand, common intention is given under section 34 of IPC and it deals with the accomplice persons who are found with principal offenders. So here, the accused Barendra Kumar denied his charge on the ground that he was simply standing outside and had not fired at the deceased, just that he was carrying the pistol. The court did not take his submission, rather stated that being an accomplice, Mr. Barendra Kumar shared the common intention as any convict at the crime scene and hence he cannot ask for lesser punishment. Same happened with Nirbhaya incident, wherein Mukesh, the bus driver, pleaded that he should not be guilty of gang rape and murder since he did not involve in the crime, rather he simply was driving the bus. The court observed therein also that Mukesh had common intention. By being part of the crime, he could have stopped the vehicle. He was aware of what was happening inside the bus. He heard the screams, the fights, the aggression. Did he stop the bus? He did not. That means he facilitated the perpetrators by letting them do the crime. Rather than stopping it, he mercilessly let his companions perform the crime. Therefore, he was held liable. I hope thus all of you understood how accessories before the fact are different from accessories at the fact. Now comes the concept accessory after the fact. They are the people who comes to the scene when the crime happens. They are neither before the crime preparation stage nor at the time when it happens. They get involved as helpers after the crime. For example, the act of persons who helps clean up after the crime was committed by disposing of evidence. So naturally, their acts are not as culpable as abetment to the crime or commission of the crime. In the eyes of law, it is done after the facts, so not so culpable. Hope this video therefore makes you aware of the principle of complicity. Do read the sections 107, 34, 141, 149 and section 411 of IPC and examine how these sections are interpreted in the light of the principle of complicity. Thank you.